My lords, I'm conscious of time. At this point, we've got half an hour left on the timetable. I was going to hand you to Mr. Walsh to deal with the specific points on the Bath Racecourse, if I may.
Thank you.
My lords, as already foreshadowed by Mr. Scory, I'll be dealing with the 2 points that arise in discrete to Bath
You're
Racecourse.
going to have to speak up.
I do apologise, my lord. Is that any better?
Yeah, a bit better.
I'll do my best. The first, my lord, is a very short point on claim preparation costs. And the second is a slightly more substantial point on the proper construction of the denial of access limit in condition 22 and whether that particular limit applies on an any one loss basis.
Well, they go together, don't they, the 2 points? Don't the 2 points go together?
No, my lord, they're separate. They're separate points. Dealing with the first point, my lord, the claims preparation costs, we see these in the Bath policy, that's in the Bath Racecourse bundle, tab 5.
I understood it to be common ground. Also, it's that the result for these follows the result for the composite policies.
Yes, my lord.
Do we need to look at it then?
I only have 2 additional points to make from that, other than to show your lordship. If your lordship has seen them, lordship has seen the clause, I won't need to refer back to it.
Right.
The only 2 additional points to make on this, my lord, are in relation to 2 points made in the Bath skeleton, just for completeness, which you'll find in the joint core bundle, tab 4, page 213.
Well, we were looking at in a different place. This is the Bath policy, is it? Oh, the skeleton.
Yes, my lord, the core bundle, in the core bundle, tab 4, page 213.
Yeah.
And it's the penultimate sentence beginning with, however, for the reasons set out, the CPC limit is available to each claimant as a composite policy and or due to the retained any one loss wording and also per materially different action of the government. The composite policy argument, fine, my Lord Popplewell has already mentioned. That argument follows from what Mr. Scory has been saying this morning, but we do quibble with the wording after and or due to the retained any one loss wording and also per materially different action of the government. Firstly, claims preparation costs are insured separately to the denial of access cover. That was the argument that Bath made at first instance, which insurers accepted and which was endorsed by the judge at paragraph 379 of his judgment. This means, of course, that if Bath are right that the any one loss language is retained, it has no bearing or should have no bearing on the CPC cover. And the second related point on this paragraph 47 is that the claims preparation costs cover is in fact written on a different basis, my lords. It's not written on any one loss basis. It is expressly stated to apply any one claim or series of claims arising from a single occurrence.
Where's the wording?
That is in the Bath Racecourse bundle, tab 5, page 118. 118, my lord. The liability of the insurer under the terms of this condition shall not exceed £50,000 in respect of any one claim or series of claims arising from a single occurrence. So that is all I wanted to say on that first issue. Everything else follows from the arguments that your lordships have heard from Mr. Scory on the composite point this morning. Turning then to the slightly more substantial issue, which is the proper construction of the denial of access limit in the Bath policy. We looked at this morning, but if your lordships have the Bath bundle, tab 7, page 110, we can see the standard form that's known as bluefin wording that we were looking at earlier. And the relevant lim is B, and then with the provisos Roman 2, which contains the language at the limit of £1 million in respect of any one loss. And the issue for the court is how that interacts with condition 22 on page 64 of the policy, which says that notwithstanding anything herein contained to the contrary, the limit in respect of section 2, particular settlement terms denial of access, which is what we've just been looking at on page 110, and then it sets out some either amendments or replacement wordings for provisos 1, 2 and 3. So Roman 4 on page 110 is left untouched. Now the judge held, as your lordships will have seen, paragraph 375 of his judgment, that the any one loss wording in the proviso Roman 2 on page 110 was retained despite the amendments that we've just looked at in condition 22 of the schedule. So instead of the limit being £1 million any one loss per the standard form, it was £2.5 million any one loss after the amendments. And we say, insurers say, that this conclusion was wrong for reasons I will develop in a moment. We said, and Mr. Scory has alluded to this a moment ago, that the issue was significant because it was the difference, at least when we sought permission to appeal, between a £2.5 million limit shared between all the policyholders and something in the region of £50 million if each had its own single limit. But as Mr. Scory alluded to before lunch, the recent amendments by Bath make this fairly short point of construction assume an even greater importance. Turning then, my lords, to our submissions as to why the judge was in the way that he construed the limit, we make 4 points. The first is that there is no reference to any one loss in condition 22, and condition 22 applies expressly, notwithstanding anything contained to the contrary herein. Now, the policyholders say that the words notwithstanding anything to the contrary herein are unremarkable. That's their skeleton at paragraph 38. But the words, as your lordships will see, are in fact unique. In the 41 conditions that are set out in this schedule, they only appear once, and that is in condition 22. And we say they're important. They're important because the reasonable policyholder reading them would think, reasonably and perfectly understandably, that they need not concern themselves with anything else said in the policy about these limits, because either anything else said will be consistent with what is in the schedule, in which case it adds nothing, or it is inconsistent, in which case condition 22 prevails. So although the policyholders in this case seek to draw a distinction between condition 22 and the other clauses which refer to, in the schedule, which refer to things being deleted or replaced, we say the practical effect of condition 22 is in fact the same as that. It is de facto replacement language.
The language of amendment is replacement language, you say?
It is when read with the words notwithstanding anything to the contrary language, yes. That's the practical effect of it. The policyholders also suggest, paragraph 38 of their skeleton, that the words are unimportant because they only have force where there is something, quote, to the contrary. And they say, well, there isn't anything to the contrary here. But that would only be right, my lords, if the words in condition 22 meant or implied that the limit applied any one loss, even without reference to the original bluefin wording. And not even the policyholders go that far in this case. The second point, my lords, is that the amendment of proviso 1 makes little sense if the words any one loss were intended to be retained. My lords will have seen at page 110 that the original limit in Roman 1 at the bottom of the page was £1 million in respect of any one loss.
it's not just an amendment to proviso 1, is it? But it's slightly inaccurate, both in relation to what's described as proviso Roman 1 and proviso Roman 2 and Roman 3, because the actual amendment that's the subject matter there is an amendment both to proviso 1, Roman 1 and 2 stroke 3 respectively, and proviso 2, which is so when it says proviso Roman 1 is amended in respect of A to 1 million and a maximum indemnity period of 3 months, if we look at 110 and 111, that's an amendment, isn't it, to proviso 1 Roman 1 and proviso 2, which originally had a 4-hour duration.
I wouldn't accept the second of those arguments, my lord, because the effect of condition 22 is only aimed at Roman 1. The second half of the amendment of proviso 1, i.e. the maximum indemnity period, doesn't expressly or indeed implicitly affect the second proviso on 111, which is about effectively the policyholders. It's almost in the form of a deductible. The policyholders were responsible for it.
There's a period of 4 hours before you can claim at all.
Exactly, and then it's a maximum indemnity period
period
afterwards.
is 3 months after that.
So those sit together in my submission, and there's
Well, but is your argument that 2 is not amended?
yes, that's right. One. Two is untouched by condition 22. So proviso. So in condition 22, the first bullet point, proviso 1 is amended. That amends.
So that means proviso 1.1.
Correct, my lord, because it's referring to Roman 1, and that's all it purports to amend, expressly or implicitly. And of course, the point is that why, if this was not replacement language, would you amend the £1 million limit to £1 million again? And the judge, in noting this, said that although he agreed the clause could have been drafted more economically, this was effectively a submission of surplusage, and that didn't carry much weight. And insurers, with respect, disagree. The repetition of that limit for proviso 1 is aimed at achieving the same result as the notwithstanding anything to the contrary language that introduces the clause, i.e. this is meant to be the sole, condition 22 is meant to be the sole reference point for the parties to see what the limit for this particular extension is. In other words, the reasonable policyholder is not expected to keep a finger in this page and a finger in this page and try and read them together. When it comes to the limit itself, this is a one-stop shop here, and that's what the words notwithstanding anything to the contrary mean, defined by the fact that they repeat in respect of proviso 1 what the limit was to begin with. The third point, my lords, is that it is wrong to approach the limit with an expectation that particular language would be used to achieve a particular end. And we say this is a trap that the judge fell into, paragraphs 369 and 371 of his judgment, when he said that if the intention had been to delete the anyone lost language, he would have expected the parties to have said so expressly and clearly, and identified the new basis on which the £2.5 million limit was to operate. Now, of course, in our submission, the introductory words, notwithstanding anything contained herein to the contrary, are clear and express, and they show an intention that anything inconsistent with a maximum limit of £2.5 million and a maximum indemnity period of 3 months is inapplicable. And that would include the anyone lost wording in the standard terms. But as the policyholders rightly accept, this is paragraph 39 of their skeleton argument, with the benefit of hindsight, the matter could have been put beyond debate either way with the further express language. So when the policyholders argue, for example, that if the parties is intended to move to an aggregate limit, they could have said so, pointing, for example, to condition 7, which relates to golf greens, which provided for a limit of £20,000 in the aggregate. That point, we say, cuts both ways. if the parties had wished for the limit to be retained on an any one loss basis, then they could equally have used express language to give effect to that intention. And one sees this, for instance, if one looks at page 98 of the policy, which deals with cover for escape of water. In the middle of the page, trace and access and repair or replacement. In the event of damage.
Sorry, which page?
Page 98. In the event of damage from escape of water or oil, as insured by this certificate, the insurer will pay all costs necessarily and reasonably incurred for them in locating the source of such damage and making good. The insurer's liability is limited to £25,000 any one occurrence or series of events arising out of one occurrence. And then if one looks at the amendment on page 63, condition 17, we see that the any one occurrence or series of events arising out of one occurrence language is repeated with an increased limit. So in other words, if the basis upon which the parties wanted the limit to apply was to be retained, they knew how to do it and did so in condition 17. Now it should be stressed, of course, that there are different ways of achieving one overall single limit in a policy. Words in the aggregate can of course be used, but sometimes one sees reference to an overall limit or a combined limit, and on other occasions, as in this case, we say, one just sees the limit stated full stop, with no indication it applies per event, occurrence, claim or loss. In other words, contrary to what the policyholder seems to say, there is no magic in the words in the aggregate. There are other means of achieving the same end, and there is nothing unusual about condition 22 not going further and stating, for example, that it applied per period of insurance. There are other conditions which don't do that either. For example, if one goes back to page 64, condition 23 doesn't do that, and nor does the wording it relates to at page 115. Condition 24 doesn't either, and nor does the wording that that relates to at page 67. And as we've said in writing, my lords, the default is in any event that the limit is per policy period, and that is contained in the bluefin wording, the very first page of the bluefin wording at page 81. Under the second paragraph, unless stated otherwise, the insurer will not pay more than the sums insured, compensation limits of indemnity in any one period of insurance. Now, the policyholder seems to take issue with this by reference to the wording of the deductible or the excess, and that is at page 60. Top of the page. But all this is saying is that where there is a claim for damage arising out of one occurrence, it shall be adjusted as one claim. It's not purporting to establish a general rule of its work, and we say it would be odd if the excess tail were to wag the limits dog. The fourth point, my lords, is that when one reads the conditions as a whole, as one must, they do suggest that it is only the lower value limits that are intended to be capable of being accessed on multiple occasions. So if one looks at all the conditions which are expressly stated to be capable of being accessed on multiple occasions, they tend to be limits in the tens of thousands of pounds. So going through them, I'm starting on page 61. Condition 6 is a third line from the bottom of that, £50,000 limit, any one loss. Condition 8, £50,000 limit, each and every claim. Over the page, condition 9, advertising hoardings limited to GBP.
Well, how does this point help you? Because the original provision was 1 million anyone lost.
It
So
was,
that's completely out of line with these provisions.
but what you will see, my lord, and I will come to this, is that the only limits in these 41 conditions that are for more than £1 million are conditions 22, 23 and 39, and they do not contain any express language that they are capable of being accessed on multiple occasions. Now, well, that could be pure happenstance. We say it's unlikely. More likely is that the parties objectively intended that the higher limits would not be capable of being accessed on multiple occasions.
I wonder at what point some of the cross-reference points you've been making, looking at different clauses, become pedantic lawyering.
Well, one could see that. Well, there's always a balance to be struck between.
I mean, here, the broad approach would be you look at the original clause and then you look at this clause and you'd say, what would the reasonable person think had happened here? And the question is, would they think that any one loss had gone?
Yes, ma'am.
And this sort of detailed examination of all the other clauses and whether or not any other clauses which are in that amount, surely it's exactly what the Supreme Court said we shouldn't be doing.
Well, I wouldn't accept that, my lord. I would suggest that there's obviously a balance to be struck between doing one's best with the limited materials that we have to try and make sense of.
And the difficulty with the argument, and putting the point in a slightly different way, the way my lord put it, is that this wording is pretty dreadful anyway. I mean, it's simply not a sort of model of clarity on any view. And this is as so often with insurance wordings. So, you know, these sort of detailed points as to what other provisions may or may not include doesn't seem to me to take you very far, really.
My lord, I don't think anybody in this courtroom would disagree with the first part of that sentiment, which is it's not brilliantly worded. But the net result of that is one has to try and do one's best with the materials that one has. And if I am pushing it too far and being a pedantic lawyer, then I stand corrected. But try the broad point. The broad point from this fourth submission is just if you look. Don't think this would be lost on a reasonable policyholder. If you're looking at where the limits are stated expressly for more than £1 million, none of them contain any express language that it is to be accessed on multiple occasions. Whereas I've given you some, but there are others one could give. The other occasions where limits are expressed to be capable of being accessed on an any one loss basis, any one occurrence basis, or whatever it might be, they all tend to be in the tens of thousands of pounds. And so we do say that would be a relevant consideration for the reasonable policyholder. And picking up in the few minutes I have remaining, my lords, just on the point that was made by the Chancellor about drafting just now, because it is relevant to one further argument, and that is on contra preferentum, which has been raised by the policyholders. Now, even when one is dealing with exclusions in a contract of insurance, the courts have been extremely reluctant to reach for the contra preferentum rule. My Lord Popplewell declined to do so in Brian Layton because one has to read the cover and the exclusions holistically to ascertain what the cover is that's provided, and in those circumstances simply importing the contra preferentum rule is inappropriate. But even if the court were minded to invoke the principle, the rule in principle, we say that it isn't obvious that that results in a construction against insurers. Critically, my lords, this is not the insurer's wording. This is the policyholder, broker's wording, Bluefin's wording. And indeed, if one looks at page 87 of the bundle, the court will see under the heading reversion of cover that the terms and conditions of this certificate are only available to an insured who has appointed Bluefin as their nominated broker. In the event Bluefin cease at the request of the insured to be the nominated broker, the insurance provided by this certificate shall cease, with effect from the date that the insured appointed a new broker. If the insured appoints a new broker during the period of the insurance, then with immediate effect, the insurer will provide substitute cover subject to the terms, conditions and limitations of the mutual insurance company policy, which, pausing there, is the policy that is applicable in Starboard. So, if the court finds itself minded to say plague on insurer's house, for the contra referendum, we say that it is relevant that this is not the insurer's standard wording. And we also say that where one is dealing with a provision which is simultaneously a grant of £2.5 million worth of cover and a limit on the insurer's liability, it is in fact not easy to identify who the profferends would be of that clause in any event. So we say that as a last resort, the court should not reach for that rule. And instead, if one is left with an unhappy place where one is left with something that is ambiguous, the court should, in our submission, reach for the construction which is more commercially sensible. And I would say it wouldn't I, but insurers' construction of this clause is, we submit, more commercially sensible.
Well, contra profferentum is, I think it was Lord Justice Staunton somewhere described as the last resort of the desperate. I mean, it's not really relied upon very often.
No, but it is by the policyholders.
It's not exactly a compelling point with.
I don't think so, my lord, either.
It's often relied on by counsel, it's not so often relied on in judgments of the court.
So we draw, I'm moving on to business common sense then, which is often relied upon by the in the courts and their judgments. And I recognise, my lords, that there's only so far I can push this point, because you don't have visibility on things like premium, the state of the market, and so on and so forth. But again, doing what I can, and at risk of being accused of being pedantic lawyering in the last 4 minutes, I just want to make this one point. If we go to page 57 of the bundle, we see the business interruption limit. Mr. Scory took you to these this morning. Under B, if you were scratching your heads about what the various limits apply to, it's not obvious at all from the policy wording. But you can take it from me that there is a spreadsheet, and I think you may be shown this later, that indicates that the 12-month indemnity period is applicable to racetracks. The 24-month period is applicable to golf courses. And the
Sorry, which page are we on?
so this is page 57, my lord.
Yes.
If one looked at B and the relevant sums insured / estimates / limits under B,
Yeah.
you might have looked and thought, well, hang on a sec, 68 million 12-month indemnity period, but then 24-month indemnity period, 25 million, what's going on here? And the answer is they apply to different types of business. And it doesn't matter for present purposes, but just to explain what you're looking at. So the biggest single limit under this standard or primary element of the BI cover, that is on a declaration linked basis, is tied to estimates of revenue, quite obviously. Now, in the holder's case, the denial of access extension to this primary cover gives each policyholder a £2.5 million limit per loss. So if one is considering insurers' maximum exposure, there are 22 policyholders and therefore a theoretical combined limit for one loss for each of them of £55 million per loss. And that is not that far off the single largest limit in section B for the primary BI, and that's for a single loss affecting all policyholders. And obviously it would dwarf that sum with two losses across the whole business. And although the policyholders here are only relying on limb B of the clause, there is, of course, your lordships would have seen similar covers under other limbs. So we do say...
You might say that even before you get to 2.5, 1 million times 22 pretty well draws, certainly, it may not draw the 68, but 68 certainly draws the 16 and the 25. So I'm not sure how far that point takes you.
Well, the point is this: if the policyholders are right on construction, one does end up in the slightly unreal world of limits on a single BI extension, potentially running into tens, hundreds, millions of pounds, when we know from the declarations of earnings in section B that the revenues that they are actually getting into the business as a whole are never going to require limits at that sort of level. And so
My Lord's point is you get that from the unamended bluefin wording.
we do, but it's a starker point, my lord. I'm sorry, I apologise, I hadn't picked it up. But yes, I accept that, but it's a starker point with this amendment, we say. So if one is in that fine balancing act of saying if it's ambiguous, and of course we say it's not ambiguous for the reasons I've given, but if it is ambiguous, we do say that this idea of limits upon limits upon limits running to well in excess of what the business was actually ever going to earn anyway, does point to the insurer's construction being the more commercially sensible.
Yeah.
So unless I can assist your lordships further, it's past.
Thank you.
Those positions.
Mr. Kramer.
My lord, I'm the lead case, which you may not have earlier appreciated. We're the lead case on composite policies.
Yeah.
That's Bath, and you'll have seen that our skeleton therefore comes first and is a bit longer. My lord, you'll have seen, just to set the structure again, you'll have seen the grounds of appeal. If you could just go back again to the insurer's appeal core bundle.
Yeah.
You might have a new tab 15 with red on it, and I know you don't like the red very much. It wasn't me, my lord. But if you don't have that, then you've been shown the earlier version at tab 11 before. This is the grounds of appeal. Just to situate you, my lord. So we have ground 3, which is the composite policy issue, which affects myself and Starboard, Mr. Gruber's client. Then we have I'm jumping ground 4. We have ground 5, which is claims preparation costs, and I have nothing to say about that because that follows the composite policy issue 100%. And then we have ground 4, which is the amendment point that Mr. Walsh just dealt with, which I will also deal with second and therefore tomorrow. And just to avoid jumping up and down, I'm going to do that before I then sit down, and Mr. Gruder's then going to have a short time on composite policy, and that will be the entirety of policyholder submissions, and then it will be Mr. Scory's reply. Yeah. That's the plan. My lord, just before I get into composite policy, there were two, I suppose, preliminary points. The first one, it's probably worth seeing the issue, the composite policy issue, which is in Mr. Justice Jacobs' judgment, which is at tab 1 of that same bundle. And the issue is at page 70. And it's issue 21A. And it does the limit, the denial of access cover apply per premises. Well, that's gone. We're just arguing per claimant. And we get to what anyone lost means in another hearing. But the point to make here is this doesn't even mention the words composite policy. The issue is not limited in any way. And the start question of whether the limit, be it 2.5 million aggregate or 2.5 million any one loss, whether that applies per claimant or not, that is the issue that Mr. Justice Jacobs decides. That's the issue being appealed. And therefore the parties had previously agreed, and the position we're in is that we must first decide, as I think you and my Lord Justice Popplewell said, to whom, as in the loss question of is it anyone lost to whom, and then later we decide anyone lost. And that's the structure that the parties have agreed, and Mr. Justice Jacobs decided on that basis, leaving off the question of anyone lost's meaning, and leaving for us, as he decided, whether the 2.5 million, anyone loss or aggregate, which is the issue 4, is per claimant, per contract of insurance. And just to turn to that point, because my Lord cavilled slightly at the, what I think my Lord called the semantic point, which is not unfair, I think. But just to show you, there is a crackling, unless I'm having a stroke.
Is it going to be that microphone there? Might want to switch it off sometimes.
Thank you. If my lord just looks at my learned, I can show you the point and then explain it. If my lord just
Yeah.
looks at tab 2, so that's my learned friend's skeleton, at paragraph 42 on page 176. So this is the question of, and it's a side issue, but it may be one my lords want to deal with, this being a court appeal addressing composite policies. It's the question of whether composite policies give rise to separate contracts of insurance or separate insurance within one multilateral contract. And as my lord says, it may not matter once one understands that they give rise to separate insurances with obligations that are essentially bilateral rather than multilateral. But I do rely on the fact that my learned friend himself describes the composite policy as taking effect by way of separate contracts. He does that because he doesn't appeal Mr. Justice Jacobs's finding that that's how composite policies work, which he said at paragraph 266 of the judgment, which is at tab 1, page 57. He was repeating what he had said in Technip, that's at page 159, and what had been said in Corbyn and King at paragraph 231.
Hang on a minute, let's just have a look at what, sorry, paragraph.
It's very short because, yes, it wasn't disputed. Paragraph 266 at page 57, that bundle. It's just that composite policies take effect by way of separate contracts.
Yeah.
Which that wasn't appealed as a basis for Mr. Justice Jacobs getting it wrong, and indeed my learned friend adopts it in his skeleton, and Mr. Justice Potter said it in New Hampshire, and it was said in Corbyn and King and Technic. Now, it's open to my lords to say that it matters or it doesn't matter, and that in any case you prefer one analysis or another. But I do just want to highlight that until this point we've been working on an agreed basis that it's separate contracts. And I, for my own part, don't see that as problematic, that one document can give rise to separate contracts, even though those contracts may or may not have clauses or limits that aggregate or refer to other parties' contracts and their insurance. And I, of course, don't argue that a composite policy could never have aggregate limits across the different contracts. So we come back to my lord's point that it may be just semantic, but I did just want to highlight that because it may be something that comes up. My lord, in the judgment. If we could also, while we're in the judgment, just briefly look at the insureds for my policy. That's at page 75, paragraph 362, which is a useful summary. And the gist of that summary and the agreed facts that underlie it is that there were 22 claimants. Claimants 1 to 19 each managed either one venue or a couple of venues at a single location. So sometimes, in 5 cases, there was not just a racecourse but also a pub, or not just a golf course but also a hotel. But they were all at different locations around the country for the 19 locations for 19 claimants. Claimant 20 was the exception because it had greyhound tracks at 2 locations. And claimants 21 to 22 operated across the group without their own locations, and I can briefly show you those facts, which is in, I think, the Bath bundle, which says case-specific bundle for Bath Racecourse. My lord, it's right near the back in the final tab, it's at page 151 to 2. So it actually starts at 149, but 149 through to 151 are just the detail of each claimant and where the racetrack is and that sort of thing, and the address of the premises.
These are the assumed facts, aren't they?
These are the agreed facts.
Right.
There are some assumed facts that start at paragraph 25.
Okay.
And just to explain claimants 21 and 22, that's at paragraphs 22 to 23. The claimant 21 at paragraph 22 did management and operational services. It currently has a claim that's been quantified at £0, although it's been included as a claimant. And there is a substantial claim for claimant 22, which managed the IP of the various other companies. Paragraph 24, which is an agreed fact, is also relevant. That the claimants presented independent figures for estimated gross revenue. And while we're here, it's also worth skimming the assumed facts at 28 to 32. I.e. they were managed separately rather than on a group basis and accounted separately as well. As separate companies, so unsurprising. So I'm not going to go through them. If you look at paragraph 33, that's just one example. It's a racecourse with 6 food and drink outlets. It has 20 flat races in a season and other live events and weddings and whatnot. So each venue had different, some of them similar, some of them different businesses, which were therefore affected differently with different races, and they were affected differently by being a golf club rather than a hotel rather than
I mean, the claimants are in the arena racing group.
Yes.
They're not all in the same ownership. They're not in common ownership. Is that right? Yes, they are.
I think there's a parent ownership.
There's a parent.
Yeah. A point we make in the skeleton is during the period of the insurance, a claimant could be sold. There's no condition that says they have to remain in group ownership. One could be sold and become an outside the group. But as is common with a composite policy, there's usually going to be some corporate relationship between them, or else it's not convenient. So yes, I think they have common ownership.
They do. Okay.
Get that from paragraph 1 of the agreed facts.
Yeah. Well, Mr. Day points me to paragraph 1 of the agreed facts, which says that they're within a group of companies. That doesn't actually.
No, I mean,
It
doesn't really matter.
Yes, my lord.
I wondered whether they had the same shareholders or the same directors or whatever. I suspect not.
So, my lord, if we also just look at the particulars of claim briefly, that's at tab 5. And if you look towards the end at page 36, the detail of this is not important, at least today, but what that appendix, which is appendix 2, shows is the different dates on which the different venues opened and closed and which regulations they say they were subject to. And then appendix 3, which follows at page 43, shows the different claim amounts, which range up to 14 million as the highest. My lord, before we get to general composite policy points, I'm going to go to the policy itself, which is at tab 7. You've been there already.
Right.
Now, my lord, you, in page 1, there's material loss or damage, and then on page 55 of the bundle, then page 57 is the BI, and Mr. Walsh pointed you to, and I think Mr. Scory earlier, section B has 3 sections, 12 months, 24 months, 36 months, and different sums insured, estimates, limits. And as he pointed out, I do have a copy, I don't think we'll need to look at it, but I'm going to wait till you ask me. There was underlying that, as one would expect, a spreadsheet which had different rows for each company, and we saw in the agreed facts that they presented figures separately. And those add up to these numbers, or at least they would have done. The spreadsheet we have for irritating reasons is actually from the prior year because it couldn't be found. This was addressed at trial, but I think, and from what Mr. Walsh says, it's pretty clear it's agreed that the parties reached these figures by adding up the sums insured for the different venues, and some of them, as he says, racetracks only had a 12-month period, and their sums were added up to make 68 million, and golf courses had a 24-month period, and hotels 36 months. This is based on different times that they would estimate it would take to get the business back on track. Most typically from a property damage, of course. And what's agreed between us, although I think Mr. Scory thought it helped him, I don't think it does. What's agreed between us is that no one claimant, let's say Racetrack, could claim 68 million. So it's agreed that each claimant has its own number that is declared on its spreadsheet. Now, why does that not help Mr. Scory? Well, because what that means is each claimant knows that this is just a total, but its sum that it can claim is a separate limit. So it has a separate limit. Same for property, it's a different spreadsheet.
Well, was the spreadsheet part of the policy wording?
It was not referred to, no, but
So why is that a limit?
well, for 2 reasons. One, it must be implicitly incorporated in some way, otherwise you wouldn't know what 12 months is and 24 months and who has which. It doesn't say it anywhere in the schedule or the policy. But 2, because the parties agree between them that the limits are only intended to apply to each declared value. And indeed,
But there's a difference between an estimate and a limit.
my lord, yes. But I think we'd agreed that one would be bound by, I'll come to the settlement terms a bit later.
It can't be a limit because the sum insured, for instance, for buildings is greater than the declared values.
That's right. For that's right, and for BI, there's a clause that says there's 133% is the amount that can be claimed, which I'll come to in a moment. It's not the clearest way of doing it. Obviously, one should have referred to the schedule, but the parties agreeing that the total sum insured here is not available to any one venue rather proves that one way or another one has to arrive at the individual figure for the particular venue. In any case, there's the broader point that my lord's made, which is, well, it's clear that this was an aggregated figure and that's different to all the other figures that we're going to deal with. And everyone knows it was formed from aggregation of some individual declared values, and that's not in dispute. That's the nature of its makeup, the same for property. My lord, there's rent receivable and there's, which is not relevant here, and there's ICW, which there is a claim here. The total claim which you might have seen on that appendix is 80 million plus 700,000 ICW. It's not 3 billion. It may be that arithmetically the limits could reach 3 billion, but the claim is 80 million, and the question is whether that's limited in any way. If we work forward, my lord, you've seen quite a lot of the
When you say the claim is 80 million, where do we get that from?
Yes, so, sorry, if we go back to the Bath,
Is it
this is the
particulars
Bath
of
bundle, if we go to the particulars,
Page 43.
page 43. That total sum also appears in the main body of the particulars, but you can see how it's made
Oh,
up.
I see
on
what
page
you mean,
43.
yes, okay.
So that's the reduction in gross revenue claim that is advanced
Yeah.
in the particulars, and there's also a reference to ICW of 700,000. We haven't got to loss adjustment
Okay.
yet. There is a trial in May, my lord. So, just working forwards, we'll come back to some of the individual conditions. If we go to page 76, you'll see the broad definition of business and we have the general sorry, just in case it's relevant, if we go back to 74, I'm always nervous of any mention of premium as being relevant to construction because it's hard to see how one has the information to make it relevant. But the point was made that the Starboard premium was thought to be relatively small. The premium here is 560,000, whether it plus the terrorism. I don't know what one can make of that other than that it's substantial, but I don't make a positive point out. Well, the general wording starts at 81. And has some general indemnity wording of provide insurance described in this certificate. Unless otherwise stated otherwise, insurer won't pay more than the sums insured compensation or limits of indemnity in any one period. So obviously it depends what those limits are. And says the business is described in the schedule. We saw that already. And if we go forward to 104, which is the start of the BI cover.
Sorry, page?
104.
Yeah.
Again, business refers to the schedule, sorry, the introductory wording, which I think we might have looked at, sets out the indemnify the insured as follows. For interference with the business at the premises, but we'll look at the particular denial of access clause in a moment. The premises is defined broadly as the premises, although we've got, as I say, the schedule that makes up particular figures. And then at 110 is the denial of access wording. And it's now accepted that there was the necessary danger within 1 mile of each of the premises. So we're looking at denial of access B, and it's accepted that this prevented access or hindered use and that caused interruption or interference. And the parties also agree, I think this was a point Lord Justice Popplewell made, the parties agree that this clause only applies on a claimant by claimant, premises by premises basis, i.e. the claimant needs to point to the danger within 1 mile of its own premises, preventing or hindering use of the same premises, rather than use of a different premises, even though the premises is defined compendiously. It's not being read compendiously, it's being read on a per claimant basis. And that's why it was necessary for there to be danger or disturbance within 1 mile of each of the premises, which is, as I say, now not disputed. And then we have the 1 million any one loss and the 4-hour minimum. And we agree that the 4-hour minimum remains, whatever happens with the amendment.
Yeah.
And you've seen the claims preparation costs, so I don't think we need to go to that, my lord. And you've seen the amendment, and we don't therefore need to go to that right now, we will tomorrow. So the question is, looking at either that clause, well, they'd have to look at that clause on 110 and they'd have to look at the amendment on 64. Does the relevant business, the claimant in question, it might be a racecourse owner or have a hotel in a golf course, do they read these limits and think, well, those are the limits for me, for my insurance? 1 million any one loss, 2.5 million any one loss, or possibly possibly a flat limit, says Mr. Walsh, and he'd say 3 months maximum, so presumably once that 3 months is triggered for anyone, then that's the end of that for all other claimants. Or would the claimant think, on his view, the claimant would think, no, that's across all of us. I'm going to have to find out whether the racecourse in Newcastle is already claimed and the dog track in Sunderland, etc. And we say, no, that they're going to read all of these limits, and it's natural that they do, and I'll get into why it's natural. They're going to read all of these limits as being limits for their insurance, and that's the natural way, that's the expectation when you're reading a composite insurance, your contract of insurance. It may be that the document also embodies other people's contracts of insurance, but in your contract of insurance, these are your limits for your insurance. Now, why is that? Well, the first point, and it has been touched upon, if we perhaps most easily be just taken in McGillivray, we go to the, I think it's Joint Common Authorities, Volume 3. Yes, 4. Volume 4, tab 3.
These aren't in the Insurers Appeals Authorities.
No, they're in the Joint Common Authorities because some McGillivray is used in the furlough appeal, so it was thought at some time by someone, perhaps rightly, that it was useful to have all McGillivray in one place. So the answer is no, they're in a joint...
I'm afraid I've brought the authorities bundles that are said to relevant to Insurers Appeals. You really think that was foolish?
My lord, I don't think it's going to matter. I don't think it's going to...
Which paragraph do you want us to...
I was going to go to paragraph 1-202. It's not a... so that's at page 1341. I don't think my lord needs to pass the words carefully anyway by having it in front of him. It says only something that's been said many other times, that it's become commonplace for reasons of commercial convenience to insure the interests of a number of insured persons under one policy of insurance, either because it concerns property in which they're all interested in, or because all companies within a group can obtain insurance more effectively and cheaply through a single policy. So it's a group buying point. And that sounds very anodyne and uninteresting, but it's quite important because it goes to the point that Mr. Justice Jacobs made, which is if the distinction between separate policies and a composite policy is seen as one of convenience, which is how it was described in general accidents as well, I think, and since. And this is what brokers will know when they're advising their clients. They might say, well, it can be convenient for you to go under a composite policy because you might be able to access larger insurers if you all band together. Then it's not reasonable for the reader to think that it would radically change the application of the limits.
Slightly struggle to understand what is meant by a policy if it is not a contract.
Well, the policy is what we're calling the document.
Yes, it's a document, undoubtedly. But does it have any more meaning than that?
Well,
What
quite.
surely it means is that it contains a number of contracts, and of course they must be construed together because they're in one document and their provisions overlap.
But it may also contain a joint contract. I mean, when the insured is made liable for the premium,
Well,
who's liable for the premium?
yes.
Are they each pro tanto liable under separate contracts? Or are they jointly and severally liable?
It depends on what it says, and that has been obviously the subject of some decisions because it mattered where you'd repaid premium, I think it was.
But certainly conceptually,
Yeah.
one can imagine it involves both separate contracts and, for some purposes, an overall contract to which all the insurance.
My lord, I think that must be right. By group buying, you're having a group total sum insured, but you're also, as you say, having a group premium. But some of the respects in which it's treated, the respects in which it's treated as separate insurances are more important than the respects in which there's an overarching or, as I think Mr. Scory said, framework contract. And they include obviously for avoidance, etc., and we'll come to that in a moment. But I think my lord's right. There's one document that includes a number of identical contracts, i.e. it's a contract between the insurer and A, contracting the insurer and B. But my Lord Justice Popplewell makes the point that there may be a contract between all of them together as regards perhaps premium or some other matters of administration maybe, or who knows, you could look at some of the boilerplates and that may be the case. But the key point is that the insurance, the risk transfer, the obligations are bilateral, and that is given effect to by principles of insurance law, which I'll come on to in just one moment after just showing you my learned friend's skeleton. So my learned friend, you've been debating this a bit with him already, but it's in the insurer, it's in the core bundle, tab 2. And just to see the way my learned friend puts it, and he says,
Sorry, page?
sorry, so start at page 177. He says at paragraph 46.2, that whether a document is a composite policy, or whether it would be understood, say, by an insurance lawyer, italics, and the legal consequences ought to be irrelevant to construction. I don't think today he was saying it's irrelevant. I think he softened, but he said there it was irrelevant to construction. At 47, he says it can't and should not determine proper interpretation. I think that's probably right if determine means cover the whole field of the construction exercise, because one has to, of course, read the words. And then at 49, the second sentence he says, well, it being a composite policy is a legal construct and shouldn't create any form of rebuttable presumption. I think the point that I want to make at this juncture is that it being a composite policy doesn't just have interest of an academic basis to what number of contracts there are and whether there's interesting tweaks to privity and how people are doing their contracting. As we all know, it has very substantial implications for how avoidance and willful misconduct work. So what we know about the implications of deciding that contracts are composite are, for example, that the parties have agreed and their intention is that if one party makes a fraudulent claim, the insurer only has a remedy against that insured. And if one insured commits non-disclosure, that does not give rise to avoidance against another insured, unless there's some contract term to the contrary. And that's not disputed and it's trite. But what it tells you, and those things could be contracted out of course, but subject to contracting out of them, there's a strong presumption of that, because by identifying a contract as composite, what you've identified is that the parties intend their risk to be siloed and not affected by the conduct of the other insureds. And that is what it means to say the contract has been determined to be composite. It's that the parties intend those effects. It's put quite well in the Insurer Authorities Bundle 2. This is within the Technet case
Yeah.
at tab 19. Although it's actually within a summary of the argument of Mr. MacDonald Eggers. If you look at page 737, if you look at paragraph 136 at 737, we say the effects of a composite contract are on a theme. The theme identified there, and as I say, this is under Technip's argument, this is not the judgment of Miss Justice Jacobs. The theme identified there is that no conduct or knowledge on the part of one assured can be attributed to another, and that includes the application of policy limits. And we say, well, that's right. The limits issue is entirely consistent with the intention that's been identified, that each party can just get on and worry about their own insurance and conduct it according to their own business and erode their own limits without reference to the conduct of the other parties, be it conduct that could implicate the enforceability of the insurance at all, but also conduct that could implicate the limits. And of course, on all of those points, I think, on all of those points, the party could contract out of them.
Well, this of course is right in theory, but one can have a substantial variation in facts. Sometimes you'll have assureds under a composite policy who are unrelated entities and who have their own interests and interests that may be in conflict, contractors or risks, for example. Or you may have a group policy in which actually the group information is all put forward by one person acting on behalf of all the assureds, so that a misrepresentation as to the information in relation to one assured will in fact vitiate all. So it's all, this is all fact specific, and we're here in the territory of a group policy for separate property but identical interests in separate property, which is it's very, very different from Samuel and Duma, mortgagees' interests and so on.
My lord's right, and indeed, even if the contracts are entirely separate for avoidance purposes, they may have the same agent, and therefore that may reach the same result.
Exactly so.
This is a point where this really goes, because in fact, as I think my lord was suggesting, our facts actually do point to the distinct interest end of the scale in a way that some may not.
Well, I was wondering when you were explaining how the estimates of revenue were arrived at.
Yes.
If it was put together in the way one might suggest, if one of those is a misrepresentation, that might vitiate the policy for all the assureds.
It could do, depending on, but that's a question of agency, that's right.
Exactly so. But
Yes.
that's this policy,
Yeah.
and that's not therefore treating it as a series of silos for the consequences that you're trying to draw attention to.
Well, my lord, I'm not sure I agree with that. Each assured, it's only their own non-disclosure that counts. It's just that they used a common agent, and therefore, ultimately, they're tied to the wrongdoing of that agent in any respect. But as a matter of their agreement, it remains the same. It's just that they've chosen to employ in practice something which implicates them in somebody else's misconduct. I mean, where this maybe goes to is...
Well, let me put it another way. the limits we saw, the 80 million, 20 million, whatever limits, are totals, and they're
Yes.
on the basis of all the information that has been provided. And if that information is inaccurate in relation to one assured, then that vitiates all, doesn't it? Assuming.
Maybe, question of fact, yes, as to how they were put together and,
So even in this policy, one can't
Yes.
treat it as though it fits simply into silos, because there are some aspects of the policy, I think you accept, which overarch the individual contracts of insurance.
arising out of the facts, yes, the agreed facts were pretty narrow and said that most of the insureds provided separate figures, but it didn't go into who that was, and maybe they used, at what point did they engage the broker, and was it all through the head of finance, and etc. So my lord is right. I mean, for me to win this ground, I just have to maintain the construction overall in the light of the policy, and we say that not only is it a composite policy and that helps us, but that everything points in that direction, because we've got separate companies with separate premises that very well could and might have used separate contracts, etc. My learned friend at paragraph 52.2 of his skeleton, I think, makes something like this point, which is a point, I think, so this is in the Insurer Core Bundle, and if we look at paragraph 52, which is at page 181, my learned friend, I think he's resisting the idea of an expectation or a presumption by saying, well, the facts can vary, and you may have group companies that are arranged on more vertical lines, and you may have those that are not. And to an extent, I don't, and I don't need to disagree with that, because we say ours is a very lateral, flat structure of individual businesses. They're in different places. The Liberty Retail case, which is no longer with you, in which the judge also found the limits were separate, did involve some businesses operating out of the same premises. So some claimants had businesses in the same premises, but we don't have that issue here, other than the overarching two businesses, C21 and 2. So we have a very flat, siloed structure of different businesses, different management, different places, doing different things within a group. So on the facts, we say, well, it very much points to separate limits. And that may go mainly to how far my lords go on saying that being in a composite policy leads to a presumption or an expectation, or whether my lords say, well, it might do, but it depends on other things. And that's probably semantics, because it depends how much you remove all the facts before you start with a presumption, and then you might very quickly leave the presumption, or you might say, it's too early to presume, I need to look at things. It's a bit like you, my lord's question of what if we have a limit on its own and it says nothing else. And Mr. Scory not unfairly said, well, there's always words. So he was resisting having a presumption without words on the basis that, well, what's the point of doing that? We for ourselves say that the nature of, in the same way that one can say, and the judges happily will say, that a composite policy gives rise, and the textbooks also gives rise to siloing as regards avoidance, and an insured will not have their policy avoided for the non-disclosure of another insured. Equally, and we say that's true also for limits, even though, as my lord says, in practice it may not be that simple, and on the wording it may not be that simple. So we say these are the general effects of a composite policy by virtue of the fact that it's for convenience of separate companies that could have had separate insurances, and it's not drafted to do anything differently. And from a starting point, if you have a separate insurance, you probably have a separate limit, and it doesn't really go further than that, but it does go that far, we say. Whether my lords want to call that a presumption of fact or an expectation or not, we say it's important because the broker, that's my lord's point, which comes also from Brian Layton, the broker advising will take into account those effects of a composite policy in order to be able to say, it's therefore really a question of convenience, but you might be able to access larger markets. Rather than, well, if we go in one policy document, your interests are very much tied to the other policyholders, and the law doesn't say that, and so the broker doesn't say that. And so the reader says, well, that sounds like a sensible idea to me, and they go home with their document and they think, well, those are my limits, those are my terms, and that's my contract, and I don't need to contact through head office or otherwise 21 other businesses around the country when I'm working out how much of a limit I have left, etc. So that's why we say the expectation or presumption language is not inappropriate and is useful, and why we say the nature is a composite policy, but also the intention that must sit behind having determined that it's a composite policy is relevant here to construing the limits question, and therefore gives weight. And yes,
Does the expectation or presumption, whatever, does it amount to anything more at the end of the day than that you have to bear in mind when you are construing it, that you are construing a number of separate bilateral relationships?
I don't think it does. It obviously depends on what one thinks the implications of separateness are. But I think that's right. The core of it is that you're separate, and by being separate, you might be expected to intend to be separate in various particular things, incidents of your contract.
Because you're not here talking about I think Mrs. Justice Cock would describe it as a question of law. I'm not sure that's right. And neither are you talking about a rule of construction, to the extent we talk about those anymore, because you're not construing one contract. What you're saying is you have to remember that you're construing several contracts, and that isn't a rule of construction. It's just simply reminding yourself that each insurer has contracted separately. Each insurer is contracted separately with the insurer. And is it any more than that at the end of the day?
It's only more than that in that it's the second half of the expectation, which is because you are contracting alongside lots of other insureds, but separately, it will be normal to think that your limits will be separate too.
Well, it might be, but then there's absolutely nothing wrong with all the insured agreeing that their limits will be aggregate.
Absolutely.
So it,
Or that they could avoid if any one of them says something wrong.
but then when you have policy wording, which makes it clear that the what is insured against is relates to each insured and each premises, then that all fits together. But it's not a presumption. It's just a matter of construing each of those contracts.
Well, presumptions are not very helpful because they should be of fact or law, and it's not really either of those. So it would be what we used to call maxims or canons, and we don't like those rightly. So all it's really saying, but I think it's useful to have an expectation or a normal because it allows the market to contract around it. It highlights to the broker and the insurer and indeed the party, well, if that's not what you want, do something else. Try and make it clear if you can. We'll obviously construe the whole contract, whatever you do, but that will be a normal incident of the separateness, which is why it's helpful for, and probably why their lordships in the various cases that we will come to, did go so far as to say expectation or generally or such, because they were hinting to the world that if this is not what you like, then contract around it. And there are cases where that's been done, which we can show you. So that's why...
Well, you can say separate contracts normally produce separate rights. And that's it, isn't it?
And therefore, limits will make more sense as being separate also, I say. My lord can pass as my lord likes.
Conversely, one might say, well, although these are separate interests, separate rights, the mechanics of how the wording is agreed is that there is a single broker who is agreeing this wording as applicable to all the assureds collectively, albeit that it gives rise to individual rights, so that it's no more likely, is it, that the wording has been agreed by reference to individual limits than it is to gross aggregate limits. It's an exercise of one set of wording being agreed on behalf of everybody.
Well, I resist that, my lord. I know that my lord has in mind that, you know, with some types of policy where it's different interests and therefore necessarily composite, but they're all interests in the same property, and one might go into a particular place with limits because of the practicalities of it. But I do say it's not equally to be said, because we've got, out of convenience, you're using a single document, but no indication that the general wording, this isn't composite policy wording where each limit has been amended to allow for the number of insureds that there are. To all intents and purposes, they appear to be standardised limits that are just in the policy of the standard wording. And whilst we have a schedule that shows the calculation of a sum insured for the overarching estimated revenue, there's no schedule that does arithmetic to come up with a separate limit for each of these other heads, which does suggest that the reader would read them as just the...
But you're back on the particular wording now, whereas
well, I don't want to leave the wording.
We were looking really at the extent to which, whether you call it a presumption or an approach,
Yes,
or whatever, it gains any intimation that one expects one or the other simply from the fact that there are separate contracts, or if you like, separate relationships. And you were praying in aid in particular that the fact that there are separate relationships has its own legal consequences in relation to non-disclosure and so on. But given that it's perfectly possible for the wording to say either of the two alternatives, limits overall or limits per assured, and given that the wording is being agreed in practice on the assured side by one broker, that's the same wording applying to all of them. How does one, before you get to the wording itself, really say, well, that points one way or the other?
Well,
if you could have either.
You could have either on avoidance. You could have that the parties are happy to be able to avoid if any assured has made a non-disclosure, given that they were broked on a agreed basis.
Well, that's a bit different because non-disclosure generally applies as a matter of law rather than a matter of policy wording. Of course you can. But generally speaking, that's the application of principles of general insurance law, whereas limits are specifically provided for or not. That's all contract wording.
Well, my lord, yes and no, but the principle of law only applies because the parties have intended a composite policy, which therefore gives rise to those avoidance consequences. And if one took the view that the parties hadn't intended separate avoidance consequences, then it probably wouldn't have construed the contract as composite. So I would say it comes down to intention in the end anyway, and that the court nevertheless has reached the view that where you go into a composite looking policy, if I may put it that way, that's your standardised intention because of the factor that my lord identifies, which is you've agreed separate insurances or separate contracts. And I do resist the suggestion that nothing on limits follows from that, although of course at every juncture I'm happy to insert subject to wording and it always depends, on which we say our facts are strong here anyway. But I do resist the suggestion in terms of future guidance, although it's for my lords, that it's entirely neutral, that it's a composite policy. And I say that Mr. McDonald-Eggers is right to draw those ordinary incidents of a composite policy together, including separate limits, such that the reader of their composite policy document will naturally, without contrary specification, understand limits to be for themselves, but understanding that it's never that simple, it's always construction. But I think where my lords...
Perhaps not just construction, but factual matrix as to what kind of composite policy you're talking about. If you have a group policy which is entirely organised by head office, all the information is fed through the head office, and they essentially arrange the insurance for the two companies that are relevant. It is composite, but it doesn't look very different from a single policy, does it?
I mean, we're getting, I would say
What
that.
I'm suggesting
yes,
is that using this composite as a label
and yes,
covers a very wide range of factual circumstances in which the degree of likelihood or unlikelihood of a default position may vary enormously.
my lord's right about that. And that's why I'm not going to spend much time on my learned friend's examples of a hull and machine policy where different bits of a ship are insured, or a D&O policy where there may be unnamed spouses. Although even then, it's always within the insurer's gift to ask the right questions in the questionnaire and rate the risk according to who it thinks might give rise to liability. We say it's not so much whether it was arranged through a central agent or head office. That will normally be the case because it's efficient. Well, whenever you've got a group that's going for a composite policy, you're going to have probably one legal point of contact with the broker, etc. We would say it's more the nature of the businesses. Are they all businesses that blend together and are just separate for accounting convenience but work out of the same premises doing the same sorts of things? Or are they separate businesses that account separately and are run separately in separate places? And why is that relevant? Because those businesses don't think of themselves as being affected in the same way by the profits, losses, claims, etc. of another business about which they know not very much. And it's also the fact that they know not very much about that business. Whereas separate claimants, separate companies that are just a matter of accounting convenience but really run as a single entity, well, maybe it's not the same position. So I disagree that it's just about who arranges the policy, but I firmly accept that the facts of how the businesses are arranged are important. And indeed, that's why we say that although my learned friend has a lot of a go at a presumption and whether a composite policy means what we say it means, he doesn't actually have much to say about the arrangement of my clients other than, well, two of them are, one of them does the IP for everyone, although even then that's a separate business. Because on the facts, he doesn't really have much on our case because the Bath claimants are so separate. They're literally hundreds of miles apart doing different businesses in different accounts under different managers. So on the facts, we get home, and perhaps that now's the time to show us getting home with Mr. Justice Jacobs. We just go to tab 1 of that core bundle, my lords.
Yeah.
So we say it's at page 56, issue 13, because the reasoning's led on Starboard. And you see over the page at page 57, you can see the facts at 265 to 6. They're the facts for Starboard. Mr. Gruder may be addressing those tomorrow, but they're quite similar to Bath. I showed you our facts. You saw at 267 Mr. Gruder's arguments. Why do I show you his arguments? Well, because at 272 they were accepted, so they became the judge's arguments. And my lords can remind themselves of the points in there. And it may be that I'm doing things backwards because we haven't done the case law yet. We do say that the judges are entirely right to look at those cases. It can't be said, well, being composite is entirely neutral and therefore the conclusion on one contract is entirely irrelevant to every other contract. We say that's wrong, and that it would be wrong to criticise Mr. Justice Cockrell and the Court of Appeal, and Mr. Justice Jacobs for looking at those prior cases, finding that a composite policy led or generally led to an expectation of a separate limit. And we say that's not incorrect reasoning. Nevertheless, it's necessary to look at the facts that you have and there was a discussion about how the businessmen wouldn't have thought they were disadvantaging themselves by putting the businesses owned by separate companies in one composite policy. Why? Because it's only a matter of convenience and there's no indication that they were intending to do anything that generally intermingled their businesses thereby. And then, if my lords probably have skimmed Mr. Scory's arguments at 268 to 271, which are similar to today's and were not accepted, he says Corbyn and King's wrong, there's no presumption, New Hampshire tells you nothing, it'd be difficult to rate. My lord's already responded to that point. It was also rejected in Technic. And that it's a single policy with separate contracts, which is of course right, but doesn't take you to where he would like to go, my lord. And then at 273 onwards, we have a focus on Corbyn and King, that not just that in Corbyn and King there was said to be an expectation, but in 276 that the considerations that applied there, which are the considerations in 275, which do apply here, premises in different locations could well be differently affected by a danger triggering cover. We looked at the peril itself, which relates to what happens within 1 mile of your own premises affecting your own business. And those all point to separate limits, we say, as Mr. Justice Cockrell said, as Mr. Justice Jacobs said. And so we say that Mr. Justice Jacobs' reasoning was entirely proper and correct, and that there wasn't a material distinction in the wordings 278, and nor does Mr. Scory point to one, and nor did he try to do that there either, as is noted at 277. And we adopt all of that, and if we go to page 65, which...
Sorry, just before we do that,
Yes.
was there any common ground as to factual evidence that it was simply a matter of convenience? That
No.
these
No, the reason...
this was written as a composite policy. I mean, it might have been that you'd get a better premium for doing that than if you did it individually because of the geographical spread or the volume of the business, or any of those reasons.
Well, certainly,
So
yes.
why should one start from the presumption that the position is simply that this is no different from separate policies, save as a matter of convenience?
Well, there was no agreed factual evidence or factual evidence on the reasons for going down this route. I don't know if we even know what they are, or how the discussion went, or whether that would be admissible anyway, or to what extent it would. No one pleaded an estoppel or some such. McGillivray rightly points out that by convenience it includes potentially preferable financial terms because you're group buying, and therefore an insurer might be more interested in a 110 million business interruption policy, which is what this is, than the individual items. So yes, that might, there's not just the administrative convenience. In fact, the reasons, I think it's in Technic, I might go there shortly. The various possible reasons for doing this are set out. And I agree, they could include all of those things. But we do say that one would, without evidence to the contrary, one would naturally and normally assume that it's not a trade-off for a radically different type of cover because of the origins of the composite policy and how it's seen to be an equivalent to the separate policies. The word convenient is entirely misleading if, and it's the word that's used in the cases, if actually the nature of the cover and the limits is radically changed by that step. It would be a very bad idea unless you explicitly have that discussion and multiply the limits by a certain number and all sorts of things, or change the wording. And my lord is right that, of course, maybe some of that had happened in any case. We really don't know what happened. But the reasonable reader doesn't have access to that information, so they're just going on the normal. And we say the normal is to assume there's no intention for a radical change, given that the convenience reasons are obvious. And you have already seen, my lord, at page 65, the one paragraph. I think that's the wrong page. Sorry, that's Liberty. Oh yeah, sorry, I'll show it you anyway, sorry. Paragraph 307, so Liberty Retail was in dispute at trial, and the same issue arose, that's page 65. And that case is now settled, but you can see issue 19 is also the composite issue. And at 311, there was a discussion of that issue. And for Liberty Retail, set out at 312 and following, 6 claimants conducted business at 4 insured premises. And it explains how many of them at that flagship Liberty Retail store in London. And then at 322, essentially, nevertheless, the arguments were the same as in Starboard, and it wasn't suggested that there was anything in the Liberty Retail policy to a different result, and therefore the same conclusion was reached, which is, that's now settled, so that's not appealed. And then paragraph 346, page 70, you see the issue as it arises for Bath, which I've shown you already. And then at page 78, paragraph 374, you see the very short reasoning on the Bath composite issue. And that's, it's obviously abbreviated there, but the judge was well aware that the issue was, does the limit apply per claimant? So he was construing the policy, but he was relying on the fact that Mr. Scory hadn't really differentiated the different policies himself, and therefore the points were largely as to general approach. He wasn't saying it doesn't matter what your individual facts are. But we say that the Bath facts, like I think the Starboard facts, are if anything stronger than the Liberty Retail facts, because they're separate premises around the country that will therefore expect to be affected in different ways, and they're not even operating the same sorts of businesses. Well, some of them are and some of them aren't, but there's no single business, which comes out in the appendices because it shows they're actually pleading separate interruptions, etc.
Yeah.
Now, my lord, there's a number of limits, and we only really have to deal with the one that we have to deal with today, but I would just show you as an example, because it's a bit cleaner. If we go back to the policy itself, which is in tab 7 of the Bath bundle, if we go to page 71, condition, that's the right page. Sorry, my lord, that's the wrong page. If we go to 61, condition 7, it's another condition, but it's, and this is relevant also to Mr. Walsh's argument. This one specifies that there's a 20,000 limit in the aggregate for damage to golf greens, fairways, etc., caused by misuse of fertilizer or pesticide. And because it's in the aggregate, there's no question about what does anyone loss mean or whether there's an anyone loss clause. So it's a bit simpler to talk about. And we say the implications are that the claimant 8, which owns the Newcastle Golf Club, would read this condition and think, well, I've got up to 20,000 for pesticide damage to my fairways, and I don't need to know whether claimant 12 has already made a claim on its golf course in Lingfield, 300 miles away, and vice versa. And we say the practicality of these being separate businesses at different locations just makes that the more natural construction. And it could be otherwise. You could construe in practical limits that it's hard to work out who claims first or last and how far.
Well, it's a commercial reality point, isn't it?
Yes, ma'am.
I mean, the facts of this, the underlying facts here are of all these businesses being affected by the same pandemic. But you can envisage a situation where insured one has made a claim under policy, something which relates, as it were, is localised to its premises, unless that's been communicated within the group, so everybody knows, then insureds 2, 3, 4, etc. don't know that the amount of cover that's available on this hypothesis is reduced potentially down to nothing at all. So you might find yourself in a situation where, through no fault of your own, you haven't actually got any cover on the insurer's case, which doesn't exactly make having composite policies a very sensible course.
My lord, yes.
True it is that as my lord says, you could envisage a wording that made it clear that the limits were aggregate limits for everybody across the board. But if you did that, then at least everybody would know where they stood. And in my example, they'd have to get the brokers to see if there was any possibility of reinstatement, for example.
Or you could provide for reinstatement in the policy itself.
Or you could provide for reinstatement within the policy, which you might do in my example.
Yes, and we say, so the anyone loss issue is a bit of a red herring in that it's true that anyone loss slightly points up that different claimants might end up either necessarily not overlapping each other's cover depending on one view of anyone loss, or having very overlapping claims on the insurer's construction, which is that all loss arising out of one set of regulations would have been a single loss, and therefore in a COVID type situation you all have to coordinate and there's no first claim because you're all claiming together out of a single event, if you like. But that's not going to be the typical example, even for denial of access cover, which is about an impact on a venue from something within 1 mile of those premises. It's entirely contemplated that there could be such wide area cover, otherwise we wouldn't be here at all because we've succeeded on the causation point. But nevertheless, the policy has to work across all of these. And my learned friend, I don't think, would say, well, you're right about golf greens, the 20,000 is per claimant, but the denial of access isn't. I don't think that's what he says. And if so, it becomes very difficult because we're all rather assuming that one reaches the conclusion that, save for there being particular features like an aggregate sum insured or something from a declared values, that all of the limits are going to be per insured or not. And no, it's not suggested that you have to do each one separately, obviously unless there's any specific words that really point that up. So that's why it's entirely valid for me to just go to condition 7 or any other condition and say these have to work in practice. Debris that's just Folkestone, so I forget that. Some of them are limits for only one location, so they don't really help. My lord, I think most of the practicality points have been done and explored. I'd like to touch on the case law, which is to say I'm going to touch on New Hampshire and briefly on the article by Mr. Harris, and then Mr. Day is going to deal with some of the other authorities if we have time today. My lord, nevertheless, we say that within these authorities, Mr. Justice Potter, Lord Justice Staunton, and the rest of that Court of Appeal of Lord Justice McCowan and Hall, Mr. Justice Cockrell, Mr. Justice Jacobs, and a number of others abroad that we will be coming to very briefly, have all appreciated this point that the separate interests generally and naturally lead to separate. albeit on their own facts. And we think that they were right to do so. We think there should be understood to be an expectation or a presumption. And maybe worth noting the judge's reasons for refusing permission, which were at Insurer Appeal Core Bundle, tab 7, I think. Page 254, paragraph 5. The body of law supports this position, and there was nothing in the policy to the contrary. Now, of course, I must accept that permission was given, and that's at tab 8 by Lord Justice Mayles. At paragraph 2, but it's a general point which merits consideration by this court, and that's what we're doing. But my lord, we say, not only do we say we should win, and that may not surprise you, but we also say that it would be useful for the law and the market for the court to be clear that there is a general expectation or implication or leaning or natural consequence from having separate interests and separate insurances, albeit within one policy document, and that will assist in pointing out that insurers need to contract out of that if they want to, or indeed insurers. Although, of course, it's in my lord's hands how they give their judgment, of course, and which way, indeed, that they go. If we go to New Hampshire, we touch on this at our skeleton at 24 to 5. It's at Insurer Appeal Authorities A6.
One of the insurers' authorities, yeah.
Bundle 1, yeah, bundle 1.
Tab 6.
Tab 6. This is the Lloyd's that includes the Court of Appeal and the first instance.
Yeah.
In very small writing for me, but maybe that's because I've got A5, my lord. And if we go to, my lords will recall it's fidelity insurance, and the issues are in the head note. You've touched on some of the issues in one of friend's submissions. The ones perhaps to note that you've got issue F and G, which F is whether it was composite, i.e. each insured was insured separately, and then G, which is whether non-disclosure by one affects the other, and then our issue L, of which relates to the limits. My lord, it's probably worth noting, if we go to page 143, left-hand side, this is in the first instance of Miss Justice Potter, at under I was on the wrong page. Issue F we want on 141, internal 35, left-hand side. And it was said, just under the summary of issue F, that this issue governs issues G, H, and I. Didn't actually mention that it governed or determined issue L, the limits issue. And you can see the rationale for issue F, that it's a composite policy at 143, left-hand side. And you'll see towards the bottom, the very bottom of the left-hand side at 143, there's a reference to the Lloyd's underwriter expert, Mr. Burnhope. And then there's some discussion of that evidence on the right-hand side. And this goes to an extent to my Lord Justice Popplewell's points about various different reasons for using a composite policy. And the third paragraph mentions, and this is obvious, I'm not relying on the expert evidence of Mr. Burnhope, which was largely found to be not very useful. Points out that the bigger the compendious policy that you're placing, the more insurers will be interested and potentially the better terms you'll get. And it reduces the masses of paper. On 144 left-hand side, got the advantages of administration of premium collection and makes it easier to aggregate limits if you want to. And then at 146, internal 41 on the left-hand side, there's a conclusion that I can't now find. Sorry, because I'm on the wrong page. You're probably not. Yes. Was the cover joined to a composite? So the conclusion is reached that it's composite. And then at 148, it's concluded on the right-hand side that it follows that unless there's language altering this, non-disclosure by one doesn't allow avoidance by another. And then 154 we see, again, because you have seen these, so I'll take it fairly quickly. Issue L, it's the very bottom of 154 on the bottom right. And we see the reasoning, we see on the left, and you've been shown this, that in the about halfway down you see there's a 1 million limit any one loss. And then at the foot, there's a quotation of sentence 3, which does the effects of separate limits and shows how you can do that. And then on 155 on the right hand side, halfway down, you see the answer to question 1. Sorry, the very foot is the actual answer, the final paragraph. Seems to me straightforward. Separate contracts of insurance under which the policy limits apply separately. But the express words change that in this case, sentence 3.
That's a reference back to sentence 3, is
That's sentence 3. The 1 million comes from the general wording, but the sentence 3 says it can't be any more than if it had been one insured.
Yeah.
And then we saw 157 is the start of the Court of Appeal. You see that Lord Justice Staunton gives a judgment, and it's the judgment of the court, which was, as I say, McCowan and Old LJJ. And then at 161, internal 55, there's a reference there to the evidence that Mr. Rokerson relied on from the expert, including point 2 about rating companies. And there was, in the paragraph that begins, we suppose, a good deal more doubt about whether that point's admissible, etc. And nothing in those points is of any assistance in this question. And then at 163 we saw that the appeal was dismissed on the right hand side. Before it gets to issue, sorry, I forgot to tell you that we were there dealing with the composite issue.
So
yeah, that was
this is
back
just
at
dealing
composite.
with whether
Yeah.
or not it's composite.
That's
policy.
right, back at composite, and it said that it doesn't help.
So then
So that was only issue F. Yeah, sorry, my lord, that was entirely. And then we go to issue L at 168, which you have seen and is brief. And my learned friend relies on the suggestion that, well, because it's obscure wording, it's difficult to understand the questions, and therefore this is all about particularly tricky policy. But the reasoning that we saw in Mr. Justice Potter, who said it's straightforward, and the reasoning in at least issue L1 doesn't turn on the specific wording at all. In fact, the exact opposite, because it says in general there was a separate limit, but then there's the special sentence 3, which changes that, and that is the reasoning. This policy is composite, perhaps sub silentio, and there's nothing in the policy to affect my view that the limits will be separate, other than the express wording that says the limits will not be separate, and therefore that changes the position, and that's where you end up. So Mr. Scory says at 51.1 of his skeleton that the conclusion's unsatisfactory, not convincing, and that to the extent necessary you should depart from it. On
Well,
yeah.
It depends how you,
Yes.
which end of the telescope you're looking through, really. I mean, I would read 169, left-hand column, knowing the individuals concerned, as Lord Justice Staunton having a fairly major go at Mr. Rokerson trying to run a point that he, Lord Justice Staunton, thought was completely hopeless. Hence, despite emphatic protests by Mr. Rokerson.
But the concession that's recorded in the second half of that paragraph is fatal to the proposition that Mr. Rokerson seemed to be maintaining in the first. So
It's quite.
Yes.
it's
Yeah.
That's the human story, my lord, but nevertheless,
No.
what he doesn't say is being a composite policy tells me nothing here nor there, because all I've got to do is look at the wording. He does say that in general, there'd be a separate limit, just as
Well,
Mr. Justice Potter said the same.
well, he says Mr. Rokerson's conceded that in the example he gives.
In the example, they press him on the point, and he concedes the argument. So,
Yes,
but it still is the case.
It still is the case.
You're entitled to say it. He says, well,
In general.
the answer to the question in general would be there's a separate limit for each insured. So,
now we say that's an essential part of the reasoning.
yeah, but
Now,
it's a step on the way. I
it's
mean,
a step on the
ultimately, they reach the same conclusion as the judge about sentence 3, but you wouldn't get to sentence 3 if the answer to the first question L1 was, well, actually, the fact that it's a composite policy doesn't make any difference whatsoever.
yes, and
It's all one limit.
I don't think I need to go to them. We do have some authorities on. I should add, it doesn't matter whether this is binding on you in any way, and I'll come back to that anyway.
No.
If you agree with me, it maybe matters if you don't agree with me, but just there's a couple of examples in our skeleton where we talk about what's the ratio, and without going there, the convoy collateral decision
Yeah.
is quite interesting, because that's a case as to it was about permission to serve out of a claim, and there's an analogy here because Lord Leggett, when talking about precedent, so not his own case, he says, well, Headley, Byrne and Heller is binding as to the law of assumption of responsibility, even though in that case there was a clause that excluded reliance and therefore there was no duty. And one can see the parallel with the reasoning here. Now, my Lord Justice Phillips might say, well, hang on, what are you saying I'm bound by? Because you've already accepted it's not really a question of law as such. And there's something in that, of course. He's not finding that there's the law is, but he is finding that the nature of an incident of it being a composite policy, which is a legal characterization, is that in general limits will be separate. So quite how one characterizes that on the scale of law to fact to normality, we could address further. But it's clearly a key part of his reasoning. It follows from the legal or juridical, as my learned friend puts it, character as composite. And we say, therefore, it rightly is identified and later applied, and my learned friend will come to those in a moment, as an incident of composite policies. And we say that can't be brushed under the carpet, despite the fact that facts will always affect things as they would with a duty of care or anything else. My lord, the other thing I want to touch on is the Harris article, which my learned friend actually seems to like more than he used to, because if we go to, I'll explain what I mean by that. It's that insurer authorities, probably the last one because it's three, C5, I've written down. Yeah. C5, so it's page 1292. It's a 2011 article, so it predates Corbyn and King.
Yeah.
And I should, perhaps if you leave that open, I should just show you where my learned friend relies on it. It's my learned friend skeleton, which is in the core bundle tab 2, sorry.
Yeah.
And it's at his there's a couple of spaces. It's a paragraph, page 178, footnote 7 relies on Harris for saying legal consequence of whether the number of contracts involved should be irrelevant. And then it's also at page 181.
Yeah.
It's on whether there's an issue of stare decisis arising from New Hampshire, and in his footnote 15, he relies on Harris, I think, for saying that there's no clear ratio because the primary issue was something else. That latter point I don't think Mr. Harris makes, but I don't recognise it anyway. We've seen that issue L was issue L, and issue L was decided on the reasoning on which it was decided. But if we just look at Mr. Harris's article anyway, and for its merits to see what it does say, I've just lost it there.
Volume 3.
Yes, volume 3, it's page 1292, Due Authorities. And if we go to page 1298, internal 399, we see that the essential thesis is in the second sentence at the top of that page. They should be construed as single entire contracts. So he doesn't like the idea of a composite contracting. He doesn't like the idea of multiple contracts of insurance, which may be why, despite his written submissions accepting separate contracts of insurance, Mr. Scory slightly slid towards a multilateral contract construction. And then the third paragraph, the first sentence, he says it's repugnant to consider that insureds are insured separately. Mr. Scory does not go that far. But Mr. Harris's thesis is based on disagreement with the core idea of being insured separately in any way. And then what he says about limits is at 1303, which is the page that I think the insurers put on your reading list. And there's 2 paragraphs. And the second one deals with reasoning. And he asserts in the first sentence that an arbitrary policy limit should bind them all as a maximum.
Which page?
Sorry, page 1303. So it's internal 404.
Yeah.
Second paragraph.
Yeah.
First sentence.
Oh yeah.
Yeah, and then second sentence says it should be a general fund that's exhausted by anyone's claims. Could provide otherwise, but in principle, the joint or several nature of the interest insured would appear to be a relevant issue of policy limit. That's obviously inspired some of the wording of my learned friend Skeleton. And therefore, he criticises the Court of Appeal decision in New Hampshire as striking a discordant note although he doesn't say with what it is in discord other than his own preference and advocacy. We then have the rationale for the conclusion was unexplained. Well, it's true that Lord Justice Staunton says no more really than that it's composite, therefore it must follow generally. And the footnote quotes Mr. Justice Potter saying what he says, but he says that's undermined by the decision in Amico directly and is directly challenged by this article. So the point he's making there is, well, I say there aren't separate contracts of insurance and there aren't separate insurances, and therefore Mr. Justice Potter's reasoning is wrong. But as I say, Mr. Scory doesn't really go that far. He accepts that a composite policy gives rise to separate insurances at least, and in his skeleton accepted separate contracts. So just to jump forward, 1305, bottom paragraph, says, well, the consequences of his view are that an innocent co-insured should be implicated by the non-disclosure of a guilty co-insured, but they probably have a claim against the guilty co-insured. And obviously it's not our law that an innocent co-insured is implicated by another co-insured. So he's relatively radical in his views for composite policies. And 1307, that's internal page 408, in section Roman 9, he seeks to overturn New Hampshire in the Supreme Court. And then Roman 10 on the next page is the conclusion that separate insured interests shouldn't mean separately insured. And the final, if you just skim that, the final paragraph of the conclusion says the whole approach of the law is misguided and muddled. We comment on that briefly in our skeleton at paragraph 35. We say it's radically at odds with the law, and that it puts forward no actual arguments to support Mr. Scory's appeal, perhaps more relevantly for today. My Lord, before I was going to let Mr. Day crack on with some of the other cases that it's worth briefly looking at. Can I just ask when you'd like to rise?
4:15.
Does that mean we should rise now out of
No,
convenience? Shall we?
my watch
Yes.
says we've got about 8 minutes.
Well,
So unless Mr. Day
Mr.
doesn't
Day will
want to
have it
start.
wrapped up in
8 minutes it is. My lords, if you're still in that bundle, if you could go
Yeah,
to tab 3 within section C,
yeah.
page.
Oliver Merkin.
This
yeah.
is Professor Merkin, exactly. And you'll see in the second paragraph of A0621, Professor Merkin says, although a composite policy may insure each assured separately in respect of his own loss, it's a matter of construction whether a policy is to be construed as requiring the assured to pay more than the sum insured under the policy where each of the co-insured has separate claims. That's obviously this appeal. And Professor Merkin then goes on to identify 3 cases: the public trustee case, which is a New Zealand case, New World Harbourview,
Yes.
which is a Hong Kong case, and Corbyn and King,
Yeah.
about which my lords have heard something already. I was proposing to add to that 2 other cases briefly as well. One is Stonegate, very briefly and in passing, and then a small bit on technic at the end. So in the time available, I suspect at least public trustee,
Okay.
and it might be we can pick up the others in the morning.
Yeah.
Public trustee is in the same bundle again at B1, beginning on page 1048. This is a judgment of Chief Justice Wilde in New Zealand. And we address this at paragraph 31.1 of our skeleton. It's not been addressed by the insurers either in writing or indeed in their oral submissions. And my lords will see on the first page that this case involved Mr. and Mrs. Donovan, who are named as the insured under a private motor vehicle policy issued by the defendant on the 28th of June 1966. That's about halfway through the first paragraph.
I'm sorry I'm not disparaging in the slightest, but just to be clear, I think it's a decision at first instance, isn't it?
I think it may well be.
Because I think the Supreme Court of New Zealand is actually what we would call the High Court of Justice.
Yes.
It's the first instance court.
It's a judgment of a single judge. I think it may be.
Court.
I think it may be a first instance decision.
Okay.
I mean, really, we're going to it because
No,
Colombo cites it, and so
Yeah,
therefore
sorry,
it
you
shows
did.
something about
So,
at least what Colombo says the law should
Yeah.
be. Now, if we go over the page to 1052, the Chief Justice says in the middle of the page, there's no dispute about the relevant facts. This was a tragic car accident where both Mr. and Mrs. Donovan were killed. This was a claim by the trustee as their legal representative. And towards the foot of the page, my lords will see the paragraph or the sentence beginning in consequence. If I could ask my lords just to read from there through to the top of the next page. That sets out the issues.
yeah.
So well, one can see the dispute is whether it's a $2,000 limit, which applies to each of husband and wife, or in aggregate across both of them. And we stay on page 1053. We can see in the middle of the page, about halfway through the paragraph that begins the obligation of the defendant, we see the Chief Justice focuses on the recitals in the policy. It says it refers to the insured named in the schedule here too, and the schedule names both Mr. and Mrs. Donovan. And therefore he concludes in the case of this policy that it must relate to both of them as individual insureds. And then at the bottom of the page, he says accordingly, so accordingly on the plain language of the second paragraph of section 3, and subject to the effect of any qualifications, Mr. and Mrs. Donovan and the brackets, therefore the public trustee, were each entitled to the full benefit of the obligation under the insuring clause. Now, this is one of those cases where that presumption was in effect rebutted because there were qualifications to the contrary. And we see that on the next page at 1054. In the second half of the page, there's an indented quote where it refers to payment shall be made under one only of the subsections in respect of one occurrence, and the total liability of the general manager shall not in the aggregate exceed. And it's the words in the aggregate exceed which therefore rebut the starting point that the full benefit should be available to the individual insureds. So that's public trustee. I think that leaves me with 60 seconds, and even going at pace, I suspect I can't do.
No, okay, well, let's leave, New World Harbour View is the SARS case, isn't it?
That's right. That's next on my
I
list.
do remember looking at it for the purposes of the test
case.
case.
Yes, my lord.
Possibly not on this issue.
I'm grateful.
Should we leave that until tomorrow morning? 10:30 tomorrow?
All rise in favour.